Today, we will hear arguments in New York Rifle and Pistol Association versus Broom. Counselors, can you please introduce yourselves?
I'm Scarlet Xing from the Baldwin School, and this is my co-counsel, Anna Magarelli. Today, we'll be arguing on the behalf of the petitioners. Mr. Chief Justice, and may I please the court? New York's proper cause laws have heavily burdened the fundamental rights of the petitioners and should be ruled unconstitutional. The decision of the lower court should be appealed. The Second Amendment protects individuals' right to keep and bear arms, as the precedent in Heller affirmed it.
So a brief fact of summary is, in this case, the petitioners, two law-abiding citizens, were banned from carrying a weapon for the purpose of self-defense in unsafe areas on their ways to and from work due to the Special Cause Act in New York. The petitioners, Robert Nash and Brandon Koch, two law-abiding citizens living in New York, each applied for a concealed carrying permit in order to bear arms. So their needs to carry the weapons in public stems from their need for self-defense, since their communities pose threats to their safety. However, under New York's proper cause laws, which requires the applicants to show special needs to defend themselves, their applications were denied and they were prohibited from keeping and bearing arms. The petitioners thus appealed to the higher court as they believe the proper cause laws have violated their Second Amendment rights of keeping and bearing arms. Thank you.
Thank you. What does the Second Amendment protect?
The Second Amendment protects the rights of U.S. citizens to keep and bear arms under circumstances when and where they believe their personal safety and properties might be threatened, and that they would need weapons to protect themselves.
Thank you. Why did the framers include the Second Amendment in the Bill of Rights?
The initial intention of the framers was to grant citizens access toward weapons in order to protect the people from the British Army as well as any other potential powers, such as, say, an overtly dominant federal or state government, from taking away people's freedom and harming their life and properties. In other words, to defend themselves from harm using weapons. It was to show citizens that the framers wanted them to have their own armed force to protect themselves from a standing army.
Thank you. What are the limits of the Second Amendment's protections?
The limits of the Second Amendment are that it gave the rights to bear arms to able-bodied people only. For example, the Second Amendment doesn't protect the rights for mentally ill or for blind people or for malicious intents. The states also have a limited power of regulating and managing guns within their territories. However, the Second Amendment doesn't limit the rights for a law-abiding citizen to carry a weapon for self-defense.
Thank you. What does the term arms include?
In the case District of Columbia versus Heller, the Supreme Court established that the term arms not only include common weapons that were used during the founding era, but also extends to weapons commonly used for self-defense nowadays, which could not be present in the 18th century, for example, handguns.
Thank you. What is the difference, if any, between the verbs keep and bear?
Keep implies buying and storing weapons, while bear means to carry the weapons. So keep and bear arms would mean to buy, store, and carry weapons. This creates the reality of how the Second Amendment allows the citizen to buy and carry arms because of what keep and bear truly mean in the Second Amendment.
Thank you. What is a militia, and why did the framers refer to it in the Second Amendment?
Militia is a voluntary army composed of a group of able-bodied men. In the founding era, only white adult men were considered citizens, and training the militia was an obligation for every citizen at that time. The framer probably used the word militia as, well, another word for citizens for a more modern sense, which now would be considered as everyone from the change in amendments over the centuries. Thus, by referring to the militia in the Second Amendment, the framers would have been referring to all citizens, really.
Thank you. How should courts determine if a gun control regulation is considered long-standing?
A long-standing law is a law that has been established and enacted for a long time. Nevertheless, whether a law is considered long-standing doesn't necessarily determine its constitutionality. For example, in the District of Columbia versus Heller, they were saying how the law was, was unconstitutional, although long acted.
Okay. What is strict scrutiny, intermediate scrutiny, and rational basis review?
Strict scrutiny asks whether the government is pursuing a compelling interest and if the law was narrowly tailored to fit the specific purpose only. Like it kind of can't affect any other thing other than this specific purpose. Intermediate scrutiny is a little looser, as it asks if the law is closely related to an important objective that the government pursues. Rational basis review focuses on whether the objective the government is pursuing is legitimate, and if the means they use rationally relate to the objective. These three levels of reviews vary from narrow to broad understanding. However, I believe that, in this case, considering how important the Second Amendment is in the Bills of Rights, we believe that it should be reviewed. We believe that the New York law really should be reviewed under strict scrutiny.
Thank you. Is there a difference between openly carrying a firearm and conceal carrying a firearm?
While both of them have the implication of carrying a firearm in public, openly carrying a firearm means the said firearm would be visible to everyone, and concealed carrying a firearm means that the firearm, especially its trigger, must be covered and concealed, thus not visible to anyone. Concealed carrying a weapon is safer since it prevents the carrier from drawing out the weapon right away.
Thank you. How should the court consider the public safety implications of licenses to carry firearms?
First of all, since in this case, the petitioners are arguing for a concealed carry permission, this shows that it is for protection and implies that it isn't dangerous as of using it freely. It is a concealed carry firearm, meaning it's not visible, so people will not have fear when not seeing it. Secondly, since the petitioner felt the need to bear arms in public, it is clear that the region is unsafe even with the current restrictions, implying that this law didn't fulfill its purpose of maintaining the security of the region, but instead was only limiting law-abiding citizens from their fundamental rights of self-defending, and thus not really acting upon its intended purpose.
Thank you, counselors. And what would you have the court rule today?
We would really like for the court to appeal the lower court's decision and to rule that New York's proper cause law to be unconstitutional.
Thank you.